This is William and Lonsdale, a podcast about the legal ecosystem and the fascinating people who make it tick. Today, your host Michael Green speaks with the Honourable Justice Phillip Priest of the Supreme Court of Victoria. Phil has had a rich and storied life in the law. The depth and breadth of his experience is vast, and in this conversation, he shares his valuable insights on the skills needed to be a good advocate and qualities of a good judge, the benefits of working with juniors as a silk and later associates as a judge in the Court of Appeal, the impact of social media on jury trials, and his personal response when he found out his former junior, Nicola Gobbo, was illegally sharing information with the police from privileged conferences with their client, Tony Mockbell. With all of Phil's knowledge and contribution to our justice system, it's incredible to think that he almost didn't have a life in the law. After failing Year 12 twice, he thought a steady job in a bank was probably not a bad option, until a conversation with a mate changed his trajectory.
I was sitting in the mate's backyard in Bulleen, drinking a VB stubby, listening to him talk about his experiences at university. This was February by this stage. And I was to start the job at the National Bank the next day, and my whole life flashed before my eyes, and I could see myself working for 40 years in the bank, working my way up to branch manager at Preston or somewhere else, and getting a gold watch for my troubles. And I thought, this really is not for me. So I rang my mother and said, I want to go back to school. And I did.
Our guest this morning in Lives in the Law is Justice Phillip Priest of the Supreme Court of Victoria. Good morning, Phillip.
Morning.
Very good of you to come in. Thank you very much.
Pleasure.
Phil, we need to clear up a couple of skeletons in the closet of the Priest family, as I understand it.
Mm-hmm.
They originally came out here on the second fleet and possibly not as paying customers.
That's absolutely true. There were two brothers by the name of Thomas and William Priest who were sentenced to be hanged at the Staffordshire Assizes in 1787. They'd apparently stolen 3 ewe sheep from a butcher by the name of Chillingworth, and the carcasses of the sheep were found buried in Thomas's backyard, so the evidence was pretty compelling. They, however, were recommended for mercy by the justices of the assizes, and King George III exercised his prerogative of mercy on condition that they take a ship to sunny Australia, and hence they boarded the Neptune, I think it was in December 1789, and was shipped out in January 1790.
So you're pretty close to Australian royalty, having convicts in your background.
Well, that's about right. I mean, the two priests certainly produced a lot of progeny, and they were pretty prolific.
And there's also some skeletons in the priest closet more recently, on the wrong side of the law.
Yeah, well, my father came from a family of 9, and there are lots of cousins, and a few of those were scallywags.
I guess we've all got those skeletons, every family.
Well, it's funny, though, when you see your own name in the law list. And I once was looking at the law list and I saw that there was a fella whose appeal was on the Court of Appeal. His name was Lel Geoffrey Priest. Well, the unusual thing about that was that my uncle's nickname was Lel and my father's name was Geoffrey, and it was too much of a coincidence. So I rang my mother, my father having gone to God. I said, this is very strange. She said, oh, yeah, that's your cousin, who apparently was renowned as an armed robber, all unknown to me until I spoke to my mother. Thankfully, I was blissfully unaware as I was trying to make my way as a barrister that I had crooks in the family.
Yes, well, now, I guess we're going to move on to your pathway into the law.
Mm-hmm.
And it wasn't such a smooth pathway, particularly school years.
No, that's true. When I did HSC the first time at Parade College in Bundoora, I spent very little time of the school year at school as a result of illness, and failed HSC. And my mother wasn't going to let me hang around the house, so she insisted I get a job. And I got a job with the National Bank, and one Sunday afternoon I was sitting in the mate's backyard in Bulleen, drinking a VB stubby, listening to him talk about his experiences at university. This was February by this stage. And I was to start the job at the National Bank the next day, and my whole life flashed before my eyes, and I could see myself working for 40 years in the bank, working my way up to branch manager at Preston or somewhere else, getting a gold watch for my troubles. And I thought, this really is not for me. So I rang my mother and said, I want to go back to school. And I did.
To Gagan College in Broadmeadows?
That's right. And that's where I met my wife. And in fact, the 21st of April 1974 was the first time we ever went out together. So that's 51 years ago, and we celebrated that the other day.
So regardless of the education, Gagan College was very fruitful for you?
Well, it was. Gagan then, it's now gone. It was absorbed into Penola College, but Gagan then used to take all of those people who couldn't fit into Catholic mainstream education. They had a very different approach to schooling. There were no uniforms. You could sort of wear your hair down to your knees if you wanted to, and it was very relaxed. You're on first-name bases with the teachers and so on.
But even so, your marks weren't good enough to get you into university.
Well, what had happened was I had an application for special consideration in when I did HSC the first time.
Because you'd missed most of the year. You'd been ill most of the year.
Because I'd been ill, yeah. And the VUSEB had told me that if I repeated, they'd give me credit for the subjects that I'd passed. I'd passed English and English literature, and they wouldn't readjust the marks by 10%. So when I repeated and the marks were published, not only had they not given me credit for the subjects that I'd passed, but they had readjusted my marks by 10%, so there wasn't much left open to me other than, advanced street sweeping or something like that. And it was quite soul-destroying at the time. I mean, having, repeated with a view to doing something other than working in a bank.
So how did you get into law school?
Well, my father was the deputy city engineer and then city engineer at Preston, which was the equivalent then of a CEO. And he was very friendly with a fellow called Carl Kirkwood, who was the local MLA, and Carl was a lawyer. My father told him this tale of woe, and Carl said, well, why don't you approach the Council for Legal Education, and put him in touch with the secretary, who was a fellow called McPherson Gibson, and he very graciously said that they'd accept me into the article clerk's course, and the only condition was that I had to pass all of the subjects in the first year if I was to remain. And in that first year there was criminal law and procedure, introduction to legal method, torts and contracts.
It's a solid year.
Yeah, well, it was. And they're pretty good. We had some pretty good teachers too. I mean, Sir Darrell Dawson took us for legal method.
For those who don't know, latterly on the High Court.
That's right. Solicitor General for the state of Victoria and then the High Court. Hartley Hanson took us for torts, and I now occupy Hartley's chamber in the Court of Appeal building. Haddon Story took us for contracts, and criminal law was Alan Dixon, who was a Crown prosecutor and later a county court judge. And, of course, his daughter is now on the Supreme Court.
And I should say Haddon Story was an Attorney-General.
That's right.
For the state of Victoria.
That's right. So, they were no slouches. They were...
Not in the slightest. Were you a conscientious student?
Next question.
Well, you had to pass, so you couldn't muck around.
Well, I did pass, but I had a particular method that I used to adopt. So I would take the textbook, underline it, then I'd reduce those underlinings to notes, and then I'd further refine those notes into cards, and that was my way of getting it into my head. I didn't find it particularly interesting going to lectures or to tutorials, and in fact I had a blue with one of the tutors in criminal law about what a case called Papadimitriopoulos stood for, and he was wrong and I was right, and I've cited the case in judgment since, correctly I might add.
That's a fair bit of confidence, Phil, for a first-year student to challenge the lecturer.
Well, it actually helps to read the case and understand it. You see,
I've got to tell you, I'm impressed by the fact you understood them. I rarely read cases as a student, but when I did, I always got them wrong. I needed to go to the lecturer to have the lecturer explain it to me.
I see. Well, it's a facility that people have either got or they haven't, and I rather suspect that still people on the court who read cases and don't understand them.
I won't pursue that line of questioning then, Phil. Phil, while doing the article clerk's course, of course, you're working full-time.
Mm-hmm.
You were an article clerk at Home Wilkinson and Lowry.
Mm-hmm.
So what was the routine, the work-study routine? How did you bring the whole thing together?
Well, we would have lectures and tutorials in the morning before work and lectures and tutorials in the evenings after work. So it was a pretty full day, particularly when you had something both in the morning and after work. And I was working at a branch office in Thomastown, so there was only myself and one of the partners, and I did everything. In fact, I did most of the litigation in the office because the partner didn't like doing it. He wanted to concentrate on conveyancing, and there was a land boom on at the time in Thomastown where we were, so I did the family law, I did the crash and bash cases in the magistrates' court, all the minor crime, and got to know a lot of barristers as a result of that because I was briefing all the time.
When I got out of university and became aware of the article clerk's course, I was a big fan of it because I thought people who did the article clerk's course after 5 years understood the whole system and where all the pieces fit together. When I'd had 4 years at university and 1 year as an article clerk, no idea. It took me probably another 4 years or 5 years to figure out where all the pieces fit together.
Well, that was one of the great advantages of it. I would have to come into town and deal with the prothonotary. I'd be dealing with barristers, clerks all the time. So there were no mysteries in the system. By the time I got to the end of 4 years as an article clerk, I knew pretty well that I didn't want to sit around shuffling paper for the rest of my life. But I did, you did know the system very well. It was during that time that the Family Law Act was introduced. So I spent a deal of my time bringing cases that had been started under the old Matrimonial Causes Act into the Family Law Court, and as a result got to know quite a bit about the way that court operated in the early days too.
I'd forgotten that. What happened to those old cases in the Supreme Court under the Matrimonial Causes Act? How did they get into the family court?
Yeah, well, there was a process because, of course, when the Family Law Act was introduced, there were thousands of cases Australia-wide that had been started under alternative legislation. They all had to be brought under the new Act.
So you were admitted in 1980 and you immediately come to the bar,
Yep.
which was not uncommon in those times.
Mm-hmm.
Why were you so definite that it was a barrister's life that you wanted?
Well, there was a film that I saw in 1975 which I found very influential, at the risk of sounding shallow, but it was a marvellous film by Billy Wilder called Witness for the Prosecution, based on an Agatha Christie play, and Charles Lawton played the part of a King's Counsel defending Tyrone Power on a charge of murder, and I thought, gee, I reckon I could do that. And I'd like to do that. So that was the main influence, I think. That and the fact that my father was a frustrated lawyer.
So you come straight to the bar. Did you easily pick up a practice? Were you immediately busy, or did you go through a lean period when you are struggling to pay your bills?
No, I was pretty lucky. My master, called them in those days Peter Murley, had a close working relationship with the Crown Solicitor's Office, and he prosecuted a lot, and he was able to, I think, help me get briefs from the Crown Solicitor's Office early in the piece.
What about the skills to be a barrister, to cross-examine, to plot out a case, to structure a case? How did you learn that?
We learned that on the job. I mean, the readers' course, I think we might have been the first readers' course in 1980, pretty close to it, and the course was very different to the way it is now. There was not a lot of concentration on trying to imbue the readers with cross-examination skills or the skills that are required to make it an effective submission. I think we did one moot court and that was about it. There was very little training given in those days in the readers' course. It was, you picked it up on the job.
And if you had downtime, you'd go to court and watch other, senior barristers running cases?
Yeah, well, that was always recommended practice. Of course, these are the days before mobile phones, so it was very important that you be in your chambers next to a phone early in the morning, and you should always be there at 4 o'clock in the afternoon. And my clerk always told me that there are only 3 places for a barrister to be: court, the library, or chambers by the phone. So,
and that was true too. And I mean, lots of work was picked up after 4 o'clock to go to court the next day.
Yeah, for sure. In fact, I picked up some of my most lucrative briefs that way when somebody got jammed. And in fact, in later years, my clerk was a great one for squeezing an extra few dollars out of solicitors, because it was, 5 to 5, and if you need someone, you've got to come up with a few extra shekels.
Now, you're admitted in 1980 and you're doing your first criminal jury trial in 1981.
Yep.
That surprised me. That's very soon to be running a jury trial.
Yeah, it was, but I had done quite a bit of work for the Crown Solicitor's Office, pleas and that sort of thing, appeals, county court appeals. So I had some exposure, and I was, too, the recipient, I think, of a deal of goodwill through Peter Murley, my master. So I think that's possibly responsible for getting a trial so early in the piece.
Do you remember the result of the trial?
Yeah, the bloke was acquitted, as he should have been. But look, I started to, after that, pick up quite a bit of jury work for the Crown, which was both good and bad. You were asking whether there was any downtime when I first came to the bar. Well, I think I was always reasonably busy, and from about 81 or 82 onwards, I did almost exclusively prosecution work.
That lasted for 6 or 7 years, exclusively prosecution work, but then you decide you've got to work the other side as well, I guess, to be a fully rounded advocate. Did you pick up defence work quickly? Was there any downtime waiting to get some defence work rolling?
Yeah, well, I said to my clerk I wasn't going to take any more prosecution work, and he thought that was a big mistake. But I dug my heels in, and I went for 6 months without a brief.
6 months?
And then I picked up 1 or 2 briefs from a fellow who was at Legal Aid, and then I started to get busy again after that. But what I did was I replaced one client with another. So I went from doing almost exclusively prosecution work for the DPP, because the DPP had then been created as an office, to doing basically legal aid work. Although that wasn't a bad thing, because back in the period I'm talking about, getting towards the end of the 80s, legal aid fees were very good, particularly by comparison with fees now. And there was some pretty good work around. And in fact, probably one of the most influential briefs that I had was as junior to Dave Ross in a murder. Learned a great deal.
There was one of your early briefs, or I think it was early VLA briefs, was an appeal against a murder conviction which led to 4 retrials.
The client's name was James Patrick Gerard Hughes, and he'd been convicted of murder at the second of his trials. The first trial was aborted. The second trial, his barrister trial was Ray Lopez. He got convicted of murder. I was given the brief in the old Court of Criminal Appeal by the VLA, managed to overturn his conviction. They offered me the brief, as was the convention then, to do the retrial, and I thought, this is a bit heavy. I said, you better give me a leader. So that was when I met David Ross for the first time. So we did his third trial and skillfully managed to get him convicted of murder again. And then...
So you appealed that conviction?
So isn't it funny? The trial judge was George Hample, and one thing about George, always ran a lovely trial. So our client got the fairest trial imaginable, save that he made a mistake in directing the jury, or failing to direct the jury, actually. despite the fact that we'd asked him to give a particular direction. So I get offered the brief to do the appeal, and I ran into George at a function, and I said, I've got the brief to do that appeal. He said, you're doing it on your own? I said, yes. He said, won't they give you a leader? I thought, thank you, George, for the vote of confidence. But anyway, I did the appeal on my own, and as Rumpole would have said, without a leader, and managed to get him a retrial. And this time the retrial was in front of Tim Smith, another marvellous trial judge. We managed to get a manslaughter verdict on what was, I think, one of the strongest cases of willful murder you're ever going to see. But there you are. Just goes to show you.
With 4 retrials, I thought, and wouldn't trust my memory, would that be considered unfair to the accused being put through 4?
Yeah. And look, I've encountered the same phenomenon as a member of the Court of Appeal, and the general rule of thumb, it's not completely inflexible, but the general rule of thumb is 3 is enough.
Yeah.
But anyway, the director in his wisdom decided that Jimmy should be tried for a 4th time, and he actually didn't get a bad result when it's all said and done.
So, Phil, after 18 years as a junior at the bar, you take silk in 1998.
Mm-hmm.
From what we've heard, in those 18 years as a junior, you always crime, no other area of practice?
Basically, yeah.
And either OPP briefs or VLA briefs?
Mm-hmm.
Mainly trial work, or you're also doing appeal work?
I did a lot of both, a lot of appellate work. And when the Court of Appeal started in 1995, July 95, there were 3 of us who got a lot of work at that time. One was Pat Tehan, the other one was Paul Holdenson, and yours truly. So I think we did the lion's share of the work, which was very useful because you got exposed. The Chief Justice sat in the Court of Appeal all the time, so did the President, of course, and you got seen. So Pat Tehan took silk in 97, and Paul Holdenson and I took silk in 98. Holdo also read with Peter Murley, incidentally.
I think you said Peter was a kingmaker.
He was a kingmaker, I think. He had a lovely set of Commonwealth law reports on his shelf in his chambers on the 6th floor. I don't think he'd ever opened one, but
they looked the part.
They were pristine.
They looked the part. So in my time as a clerk, it seemed to me that often people taking silk, it was like starting a new practice. Like when you first came to the bar, you've got to create a practice for yourself. It won't just automatically happen, or for some people. Was that your experience?
Well, look, 3 things happen when people take silk. One, their practice dies, and you frequently see that very, very busy juniors wind up silks with no work at all. 2 things remain pretty much the same. You see that, or 3, the practice takes off like a rocket, and I was lucky that my practice really took off. I mean, I wouldn't have said I was a very busy junior. I was busy enough, but after I took silk, I became extremely busy and worked in a lot of areas that I hadn't really concentrated on as a junior. So a lot of regulatory work, did a lot of work for doctors, for example, who got themselves into trouble with the medical board.
Briefed by insurers?
Yeah, for sure. I did a lot of TAC work, so serious injury certificate work and civil juries. Did a lot of occupational health and safety, which was a very big part of my practice. And that was very lucrative because, you're acting for, by and large, cashed up companies where money's not a problem. But I always did a lot of appellate work, criminal appellate work. And still, as a silk, did trials, hard sex cases principally, but private, no legal aid work.
When you become a silk and then you've got a junior, is it a different mindset as a barrister? When you're running trials on your own, you just run them, you make your own decisions, you do what you've got to do. But what about when you've got a junior? Do you have to change the way you go about things or change the way you look at things?
Well, I thought having juniors was a great boon. Not all silks know how to work with juniors. I think I was very lucky. I had 1 or 2 people who were all that good, but by and large, the juniors that I work with were terrific. And there's one female junior in particular who's now a silk of her own, in her own right. She could take, 20 lever arch folders of stuff, reduce it down into one thin volume and give me a memo with a handful of documents, and these are the only documents that you need. So if you've got a junior like that, it frees you up to concentrate on the big picture rather than having to worry about the minutiae. Another female junior I had educated me on how to settle submissions properly, because I was always very jealous about doing submissions myself, written submissions. She insisted in a case that we were doing that she must do the written submissions and I must settle them. So I took the submissions that she presented me with, I looked at them, I couldn't find anything that I would have done differently, but I changed 3 words just to put my own stamp on it. She's now a county court judge, that particular junior. Look, I do know silks still who can't work with juniors, but if you've got good juniors, you potentiate each other, and really I think the client and the solicitor get real bang for their buck.
Yeah, and I used to think in a different context, i.e. the context of football, no one person's got all the good ideas. No,
well, that's true. One case that I ended up winning in the High Court, I thought the point that we won on, when my junior put it to me, I thought it was absolute rubbish, and I argued with him uphill and down dale. I said, I'm not going to run this point. In the end, he convinced me, and as I said, that was the point on which we won.
William and Lonsdale is brought to you by Green's List, one of the leading multidisciplinary barristers lists in Australia. Green's List believe in promoting conversation around the ideas and issues that shape not only our legal system, but our wider community.
Phil, you've been quite clear in saying, on more than one occasion, that advocacy can't be taught.
That's true.
There are certain skills, surely, that successful advocates have to have. They're indispensable to being. What skills do you think a successful advocate needs, and why can't it be taught?
I think the most important skill or quality for any advocate is lateral thought, the capacity to see how the cards are going to fall. So some of the best barristers are those who may not be the greatest on their feet, but they're great tacticians, so that they can see how every decision that they take is going to affect the case. Now, that's something you can't teach. You can't teach somebody how to think laterally. The other thing is, I think the best advocates are those who let their own personalities shine through. And some of the biggest disasters I've seen in advocates is when they try to emulate somebody else's style. By way of example, you take someone like Phil Dunn, he's got a unique style, which is all part and parcel of his personality. Dunny, on a good day, is a great cross-examiner, makes a marvellous final address, but you cannot take those qualities and give them to somebody else. And I once saw a fella try and do a Dunny, and it failed miserably because he wasn't Phil Dunn.
So you've got to have the confidence to be yourself.
You do. That's one of the things I try and impart to people on the occasions that you do try and pass on advocacy skills. You've got to be yourself, for good or ill.
Yeah.
What we can teach people is how to avoid making basic mistakes. Now, that you can teach, but true advocate skill is innate and you can't teach it.
Interesting. And the Reader's Course doesn't try to teach it?
No, I think the Reader's Course, when I've participated in it, has tried to teach people how to avoid making mistakes. But look, there are things that are taught that are taught inflexibly, where, again, if you're a virtuoso, you can chuck the rule book out the window.
Yes.
So, by way of example, I once saw Dave Ross, cross-examiner, forensic pathologist, did not ask one leading question, which would have caused horror to those who teach cross-examination in the reader's school. Not one leading question. And yet by the end of the cross-examination, the pathologist had been completely destroyed. In fact, he got out of the witness box and felt he'd been done over so badly that he went to the prosecutor and asked whether he could have another go. But the way in which that cross-examination was conducted, you just couldn't teach. You had to be Dave Ross to do it.
And you couldn't emulate?
No, you couldn't. I once tried to emulate one of his methods and this is what emphasised for me that you've got to be yourself. I tried to emulate his style of cross-examining on documents, and it just fell terribly flat. When Rossi did it, it was very effective. When I did it, it was just hopeless. So be yourself for good or ill.
After you've been a silk for 14 years, on my counting, 2012, you're appointed to the Court of Appeal. How did that come about? Did you have any inkling that you were likely to get a call?
None whatsoever. I remember the day well, only because my wife took a video of my reaction. So it was a Saturday afternoon. My wife was ironing in one corner. I had a brief open in my lap, and my mobile rang, and it was the Attorney General, Robert Clark. And he said, more or less, there's a vacancy on the Court of Appeal. How'd you like to be a Court of Appeal judge? I said, oh, okay.
As quickly as that?
Yeah, it was as quick as that. I hadn't spoken to him beforehand. But when I got off the phone, my wife said to me, is that the phone call that I think it was? I said, yeah. So she's come and taken a video. This is Phil's reaction to being appointed a Court of Appeal judge.
So that's part of the family folklore now.
Yeah, well, yes, that's true.
Can I share my ignorance? When you're appointed to the Court of Appeal, do you only do appellate work, or do you do trials as well?
No, you can do trials, and I've done some. Whenever I've got, spare time and our mates in the trial division have got too much on, I'll duck over there, but others do too. So bail applications, for example, when there's a lot of those around, we'll go and do one of those, but I'll do a common law case or, an administrative law case. And as I say, I've presided over a few criminal trials.
Do you enjoy that work as much as appellate work, or is appellate work really what you enjoy the most?
I think, it's different. I wouldn't say that I enjoy one more than the other. I think appellate work is easier, which people would think was counterintuitive, but it is. Because
you've got a lot of material, there's been a trial, you've got a transcript, et cetera, and you've got, obviously, an appeal book.
Well, that's right. By the time you come to do an appeal, the issues are pretty well refined by and large. If you're presiding over a trial, it's fluid, and you've got to often make hard decisions on the run. So it's very different to appellate work in that respect.
Do appeals ever get decided on points which are not brought up in the appeal papers?
Yeah, they do. Sometimes when you're reading the judge's charge, for example, in a criminal case, you'll see some glaring error which you'll bring to the attention of the parties, and that might result in the conviction being overturned. Sometimes a point will arise in the course of argument that nobody's thought about until you start kicking it around. And that's one of the great things about the Socratic method. Often a new point will emerge, or what appears on paper to be a strong point, it becomes pretty plainer, isn't so strong once you start analysing it in oral argument.
How much non-criminal work comes before the Court of Appeal, percentage-wise? Would it be 10%, 30%?
Well, more than... The bulk of our work is criminal, so more than 50%, and the rest is non-criminal, so civil work, and which includes, administrative law cases and that sort of thing.
It appears to me that the Court of Appeal has a preponderance of former Solicitors General.
Yeah, I think, our current Chief Justice is a former Solicitor General, and I think we've got 3 others.
Is there a reason for that, is it?
Well, the Solicitor General, after the Attorney General, is the principal law officer in the state, and generally Solicitors General have given hard advice to government, have argued constitutional cases in the High Court, so they're pretty well qualified generally as lawyers to populate the Court of Appeal.
And appellate work, it's obviously different to trial work. It requires a different mindset. People who may be great trial advocates wouldn't make good appellate advocates or appellate judges?
Not necessarily. Yeah, well, I think not necessarily. The fact that you're good at a trial doesn't necessarily mean you're going to be any good at an appeal, and the reverse is true too. But there are plenty of people who are able to keep a foot in both camps. So there are a lot of people who can do both.
As a judge on the Court of Appeal, do you have a particular process or routine you follow when you are preparing to hear a case or hear an appeal?
Yeah, I generally prepare a skeleton judgment, so I'll
based on the appeal papers?
Based on the papers, that's right. So I'll set out the grounds of appeal, the facts, the arguments as they appear from the written submissions. The benefit of that is it gets the case into your head, the issues into your head, and then once I hear the case, I like to go and try and get my impressions down as soon as I can. So I'll put my impressions into the skeleton judgment. It's important too, for this reason, that very often the oral submissions will be different, sometimes radically different, sometimes only subtly different from what's in writing. And it's important to make sure that you record the oral submissions that differ or put a new spin on the written submission so that they don't get lost when you come to finally write the judgment.
And what role does your associate play in this? Do you put a lot of responsibility on the associate to help with the analysis of arguments, preparing, etc.?
I don't. Some judges do. I rely on associates, however, very much to check what I've put into a set of reasons. So even with a draft set of reasons, I get the associates to look at it and check what I've put down as against the papers that have been filed. And look, I have two associates who proofread the stuff that I put through. You would think that that'd be foolproof, but it's amazing how many times on the morning judgments to be delivered, I'll be doing a last read and something will jump off the page at me. How on earth did that happen?
Over the period of your career as an advocate and as a judge, have you formed a view on what qualities are needed to be a good judge? It's a personal question, I know, Phil.
Yeah, well, again, I think the main quality of a judge is something that can't be taught, and that's wisdom. And it's an indefinable quality. I mean, if you ask most people what are the qualities of a good judge, they'll say, sound knowledge of the law, experience, one thing and another. But I think I mentioned George Hample before. One of the things that George had in spades was wisdom. And so did Tim Smith. I mentioned Tim Smith before. Both wonderful judges, not necessarily the greatest lawyers in creation, although they weren't bad, but they had a certain wisdom, which again, you can't teach.
Which is maybe an intuitive sort of thing?
It is intuitive, that's right. My word it is. And there are some people who, as barristers, you think they're going to make marvellous judges, and they are just bloody awful. And yet others who you think are not going to be temperamentally suited for the job turn out to be terrific judges. The other thing that every judge must have is patience, particularly in these days of unrepresented litigants, and we get quite a lot of them. You've got a great well of patience if you're going to deal with them.
I'm assuming it's a very fine line you've got to tread between advocating on behalf of a self-represented litigant.
Did you say self-represented? I won't have that language.
Oh, so, well, please,
unrepresented.
Unrepresented litigant. Are you tempted to actually advocate for them because you know that they don't know how to properly represent themselves? Well, they're not represented, should I say?
Yeah, they fall into different categories. You've got some people who are dyed-in-the-wool ratbags and are just intent on causing difficulty. There are other people who are very well-intentioned and often obscure a good case that they might have because they don't have the necessary skills that come along with being a legal practitioner. People in that category, you do try and cajole along in the right direction so that they might get the right result. But one of the mob that drives us absolutely mad are the sovereign citizens. I mean, every court in Australia has to deal with the sovereign citizens, and it's very hard to remain balanced.
Phil, can you please explain, for my benefit and the benefit of others, exactly what a sovereign citizen is?
A sovereign citizen, and they come in, there are slight variations on the theme, but sovereign citizens believe that the Australian Constitution and all Australian laws are completely invalid, and the only true law is the Magna Carta, and so, the Constitution doesn't bind them and Australian law doesn't bind them, and we get 13th century statutes and Magna Carta served up to us all the time by these people, and their arguments are completely bogus, but you've got to listen to them to a limited extent.
Phil, a topic which interests me personally as an observer has been judge-alone trials, or judge-alone criminal trials, should I say, which we don't have in Victoria and other parts of Australia do have. Have you got a view on it?
Yeah, I must say that when I first came to the bar, I thought that jury trial was, a great institution, and that if ever you're going to be tried, it should always be by a jury. But I must say that my views on that have changed, particularly in the last few years. I think juries these days are a very different creature to the juries that I would deal with back in the 80s and 90s. I've thought long and hard about what's changed. I think one thing that's particularly different is social media. Everybody seems to have an opinion these days, whether it's based on fact or not, and everyone has to express their outrage, usually in capital letters with lots of exclamation marks. So I think juries are more miserable than they once were, if that's the right word, for want of a better word. I also think that there are some cases where judges are far better suited to dealing with them than the average jury. In particular, I think child sex cases. Those kinds of cases tend to provoke very strong emotional responses in juries, which it's very difficult for the average jury, average juror to be able to put to one side. I think judges by and large are far better suited to dealing with those sorts of cases than the average jury. That said, a lot depends on the experience and the innate qualities of the particular judge who deals with the case. But as I say, I think juries these days are a different species to those that I was used to dealing with.
And I think you had a case in Western Australia where it was a jury trial, which maybe went wrong because of a strong emotional response by the jurors. That's
right. I mean, it was a case where there was a complete paucity of evidence connecting the three lads who were charged with murder with the murder, if indeed it was a deliberate killing. I think there's a lot to be said for the idea that the young fellow who died met his death accidentally, but there'd been a very unpleasant interaction between those three fellows and the fellow who was said to be the victim in the lead-up to the young fellow meeting his death. And I think that influenced the jury to an extent that they were incapable of seeing past that and weighing the evidence objectively. When it got to the Court of Appeal, the judges were able to see that the verdict was completely unsafe and unsatisfactory, and the verdict of murder was overturned. But that was a case that cried out for trial by judge alone.
At the time, you were a silk here in Melbourne.
Yep.
But you put your hand up to go to WA and effectively be a junior to a silk over there.
Yeah, well, I've seen the case featured on Australian Story, and there was a journalist in WA called Brett Christian who'd taken up the cudgels for these three young fellas. And I saw the Australian Story with my wife, and I said, I can't believe this has happened. I said, there's something that they're not telling us. And she said, but what if it is true? I said, well, if it is, it's a shocking miscarriage of justice. She said, well, you do something about it. I said, it's not my business. But anyway, she, as only my wife could do, influenced me to ring Brett Christian, the journo, and I spoke to him about it. And the more I spoke to him, the more troubled I became about it. and he put me in touch with Malcolm McCusker, who was the Silk. Anyway, the rest, as they say, is history. I looked at the papers, suggested some grounds of appeal, one of which succeeded, I might add, and we did the case in WA with some success. The boys, by the way, gave me later a plaque, a photo of them with the Hurricane, who was wrongly convicted of murder in America. They'd met him, and
interesting.
I still have that plaque.
Reuben Hurricane Carter.
Yeah.
Lives in the Law is proudly sponsored by City Maps Illustrated. Their recent publication, The Melbourne Map, is a celebration of our wonderful city. This stunning, hand-drawn illustration, which took more than 3 years to create, is available as an art print, jigsaw puzzle and calendar. The perfect acquisition for your home, office or corporate gifting.
Phil, a very controversial topic in Victoria, but really jurisprudence in the whole of Australia, has been Lawyer X, Nicola Gobbo. And in fact, she was junior to you when you were representing Tony Mockbell, the client who she was working for and working against.
Yeah.
It must have stunned you when you heard about what she had done.
Completely gobsmacked. I don't think any of us who worked with Nicola had any inkling whatsoever that she was running the rabbit and doing it in such an awful way. The thing that strikes you the most when you reflect upon it is the awful sense of betrayal, because things that we were discussing in the course of conferences in circumstances where the communications are privileged, they were being reported back to the police, who, by the way, should have known better than to receive the information, not only receive the information, but encourage her to harvest the information in the first place. Complete disgrace. And I must say, from my perspective, I think it is lamentable that nobody has been held accountable for that misconduct.
Including the police?
Oh, including the police. I think there are stories that have not been uncovered and were not uncovered by the Royal Commission. Not only their conduct with regard to Nicola Gobbo, but with regard to others too. And if you'd told me in the lead-up to the disclosure about Gobbo that this was happening in the state of Victoria, I would have said you were mad.
I think all of us would have.
But one thing that part of the fallout is because she was reporting on to the police on things that were happening in conferences. I haven't been able to do any of the cases that involve Nicola Gobbo, which I suppose in retrospect is a blessing.
I think under the rule of law that'd have to be a given, wouldn't it, that you couldn't...
Well, there was one case early in the piece where I'd been earmarked to sit on the court and involve Nicola Gobbo, and we raised with the parties whether they foresaw any problem, and the prosecution side of things thought I shouldn't sit. So who am I to disagree?
To move on to a more pleasant topic, you've got an interesting hobby or pastime outside the law, nothing to do with it, which I think helps keep you sane. Yeah, well, that's true. I have practiced karate for many years. And still do? I do. It's been a blessing and a blight. I have 2 prosthetic knees as a result of lots of hard kicking over the years. Of course, when you're young, you don't think every time you deliver one of those hard roundhouse kicks to a hard bag that you're doing shocking damage to your knees. Well, apart from that, it does help keep me sane. It keeps one very balanced. And I'm assuming it's not because of the violent nature of the pastime. There are other aspects of karate which help keep you sane and balanced. Well, karate is non-violent. I mean, that's the whole point. True karate is all about defending yourself and defending others. It's not about attack. It's about defence. Is it similar to meditation? There are aspects of karate which are meditative, and indeed most sessions will begin and end with a period of meditation. So that's traditional karate. I'm not talking about some of these meatheads that you see around. And would I be right in assuming that it helps you not take home your work? I mean, if you lived your criminal law in particular 24/7, surely it would not be healthy.
No, I think
you need to not take it home.
I think everyone needs a release. We hear a lot these days about vicarious trauma. Well, I'm not one who has ever suffered from vicarious trauma, but one does need a release from... I mean, you tend to be consumed with the cases that you do, so you do need some release, no matter what it is, whether it's tennis or bridge, whatever it is. You do need some bubble gum for the mind.
And I believe you think all people should do it, or particularly young people.
I certainly do. It's great for discipline. That's one of the things that I think is missing these days in schools in particular. The discipline that we were raised on is missing. A karate class is very structured. There's respect for one's elders. One has to obey the rules. There's a very strict etiquette which must be followed. All of these things are good for the development of children.
Phil, it's been absolutely interesting and engaging to hear what you've told us this morning about your life in the law. And so thank you very much for coming in. And to close off, what do you say, what would you say to new judges coming along in particular who need that wisdom that you have referred to?
Well, I often unsolicited write to new judges and give them some advice. And one of the things I tell them is to think about the worst experience that they've ever had as a barrister in front of the worst judicial officer. Think hard about that and don't be that person.
On that note, we'll finish. Phil, thank you very much.
My pleasure.
Show notes from today's episode can be found at greenslist.com.au/podcast. There you'll find links to things we've talked about in this episode, a transcript of the show, and some wonderful photos of our guests. If you're enjoying Lives in the Law, please tell your networks, subscribe, rate and review the show. Your host is former lawyer and Greens List clerk Michael Green. Our show is produced and edited by me, Catherine Green, mixed and mastered by Windmill Audio, and recorded by Alex McFarlane, who also wrote and performed all the music for the series. We're coming to you from the iconic Owen Dixon Chambers on the corner of William and Lonsdale Streets in our beautiful city of Melbourne. We acknowledge the Wurundjeri people of the Kulin Nation as the traditional custodians of this land and pay our respect to their elders past and present. There is no doubt that conversations about justice have been taking place on this land for thousands of years, and we are privileged to continue that discussion here today.